So, Scott, at the break, you had walked us through the history of how the Supreme Court has dealt with gerrymandering. And this is gerrymandering, of course, is not a new phenomena, but the precision and the efficacy of the gerrymandering has moved into a new era in the wake of or I should say, basically in 2010. Because of the introduction of very sophisticated modeling and data mining tools that computers have brought us. I mean, as of 2010, that was really the first year where you could isolate down to not just the block, but to the house. You know, the propensity for someone to vote for a Democrat or a Republican based upon their past voting records, the publications they read, the stores they buy stuff from, all of this data was at use and created very efficient gerrymandering to the extent that, like in a place like Wisconsin, you can have 54% of the people vote for a Democrat and have a state legislature that has 63% Republicans. I mean, that is I can't even do the math, a 14-point swing. I mean, that's crazy. And so with that in mind, the Supreme Court has taken two cases, one from North Carolina, one from Maryland. One was brought against Democrats in Maryland. One was brought against Republicans. What do you think the disposition of the court will be towards these cases?
Well, it's not going to be good. And I'm really glad you brought up the case from last term, Perez versus Abbott, which hasn't gotten a lot of attention, but really is as bad as Shelby County. So, essentially what the court said in Shelby County was, well, Congress can't force states with a history of discrimination from having changes to their voting laws pre-cleared by the Department of Justice. But don't worry, under Sections 2 and 3 of the Voting Rights Act, you can still sue, you can still, bring remedies. So, we're not gutting the Voting Rights Act. We're just taking away one remedy. But then in Perez versus Abbott, essentially the Supreme Court interpreted the rest of the Voting Rights Act to make discrimination almost entirely impossible to prove. That what Alito essentially said is racism is such a serious charge, you have to presume that legislators are acting in good faith. So even if the effects of their maps are to disenfranchise huge numbers of minority voters, then that's still not enough. That basically because the legislature is just redoing something that was created by somebody else, it's fine. So really, the Supreme Court is that these sophisticated computer models are coexisting with the Republican Party that is just not offering the public anything that it wants, and so it needs vote suppression to win. And remember, Perez versus Abbott, that's with Kennedy on board. Kennedy was in the majority on Shelby County. He was in the majority on Abbott. And John Roberts has basically been against the Voting Rights Act since he was a functionary in the Reagan administration. So this is, not just, a radical far-right faction of the Republican Party. It's as establishment as it gets. So I think what's going to, I've heard some people speculate with this mix of cases that the Supreme Court is so unprincipled that it will sort of strike down the Maryland gerrymander and uphold the North Carolina one. I don't think that'll happen. The Supreme Court can often be really inconsistent in different cases, like the way it treats abortion providers and crisis pregnancy centers for the First Amendment. But I see it as a little more insidious than that, that I see a Roberts opinion that says, look, the gerrymandering is a political question. There's no standard the courts can use, but don't worry. We're allowing Republicans to do it and we're allowing Democrats to do it. So it's not a partisan decision. I think there's going to be a lot of language like that. You can't call us partisan because we're letting Democrats do it. But of course, that's incredibly disingenuous because gerrymandering is a much bigger advantage for Republicans as the parties are currently constituted, just as it helped, Democrats when they were the rural party in the mid-20th century. And there's a couple of reasons for that. I mean, the first is simply that, Democratic voters are much more naturally concentrated, and the Constitution requires districts to be contiguously drawn. So, like in Pennsylvania, there had to be an extraordinary amount of work done just to make the maps only favor Republicans slightly. Like basically in Pennsylvania, you couldn't do a gerrymander that favors Democrats the way it favors Republicans. So for that, that basically more states are going to benefit will benefit Republicans with the gerrymandering, and you can't really do gerrymanders for Democrats in most contexts as extreme as the ones in Wisconsin and Pennsylvania. And the second thing is, and this may change, but for whatever reason, for a combination of good motives and bad motives, Democrats just aren't as ruthless. So one of the most remarkable facts about American democracy in the 20th century is that when California passed a non-partisan districting commission, this produced a map that was more favorable to Democrats than the one that Democrats themselves have drawn up. It was ridiculous that because Democrats were so focused on protecting particular incumbents, that whereas Republicans tend to be focused on what's best for our policy objectives, even if one legislator gets hurt, Democrats have often been too, and again, there's also some, that there's a sense, Democrats tend to be more committed to fair elections and fair play. It's not all bad faith or self-interest, but that combination of things means that, a ruling, even if in this case both Republicans and Democrats get held, the Supreme Court staying out of gerrymandering is a huge net gift to the Republican Party. And I think that's why they took these two cases simultaneously.
All right. So we have 1 minute left, Scott. What do you think about the future of independent commissions? Because there's a lot of people out there going, well, we just need independent commissions. That'll do it. We just got a minute left.
Yeah. Well, speaking of Bush versus Gore, conservatives made this ridiculous argument that because the Constitution leaves it to the state legislature to determine how to resolve elections, that it was wrong to exercise judicial review. But that's just stupid. Even if Article 1 gives powers to Congress, but the courts are allowed to say whether they're exceeding their powers and to interpret statutes. But we might get the same kind of disingenuous argument that because of this language about state legislatures, that it's unconstitutional for redistricting commissions to draw things, that these things have to be drawn by legislatures. I'm less sure that Republicans will buy that than that they'll get out of gerrymandering. But that, as you say, would make things even worse and be even more, outrageous in some ways. And certainly, and that's where I think there could be a difference between Gorsuch and Kavanaugh and Kennedy. That just as Kennedy and O'Connor wouldn't go for that dumb argument in Bush versus Gore and had to rely on the 14th Amendment one. That this is where, the Supreme Court's, shift to the right could actually matter. That, that kind of, sort of younger conservatives maybe find these really radical arguments more appealing than a Kennedy or O'Connor might have. So, I'm less confident about that. But as you say, that would make things even worse.
Scott Lemieux, thanks so much for your time today. Really appreciate it.